Hello, I'm Frank Hartman, and I'm a practicing attorney in Charleston, South Carolina, specializing in auto accidents and personal injury. And today we're talking about the role of social media in your trial involving your auto accident claim. With the advent of the 21st century, the role of social media has taken on a very significant, or it's had a very significant impact on trials and just litigation in general. The reason being platforms such as Facebook or MySpace or Twitter or any of the potential social mediums that people use, reaching out and making contact with another. You'd be surprised what people are willing to actually post on a social forum. And the significant thing about that is all of that information that they put up there is potentially discoverable. In order for you to comprehend what I'm talking about, you need to have the basic tenets of what is discovery. Once you file a summons and complaint and litigation begins, discovery begins. And the overall broad concept of the word discovery essentially means anything and everything potentially that could serve as evidence in the context of a trial is discoverable by the other party, and that certainly includes any potential posts that you make on any social media. And in the specific context of an auto accident case, let's say that you're talking about you've got a debilitating back problem, but you post a video on Instagram or social media where you're doing backflips across your lawn. Well, obviously the defense attorney is going to go out and they're going to look at your Facebook posting and they're going to be able to get that because in the context of discovery, that's discoverable, and you're going to have to provide them with your password and your username, and they're going to pull that video, and then potentially they're going to parade that in front of the jury, and it's going to be pretty difficult for you to maintain that you've got a long-term debilitating back issue when 2 months after the car wreck you're doing backflips across your lawn. And obviously that's a worst case scenario, but it's certainly one that I've seen happen in the context of social media, and it's something that you need to be aware of. Other things that you might consider would be, talking about how you were drunk at the time of the auto accident, but it wasn't something that the police were actually aware of or tested you for. But if you admit it over a social media, and I've seen this in the context of newspapers and online media, where people admit that sort of thing, that again is discoverable, and then they can bring that in, they can ask you about it in the context of a deposition, and then they can cross-examine you in the context of a trial and bring that specific fact up and make you out to be a liar, and ultimately it could jettison your overall trial and ruin any potential of a good verdict. So I would strongly caution anyone who's out there who's entertaining the possibility or who's in the middle of an auto accident trial, or any other trial for that matter, to be very vigilant about the sorts of things that you put up on social media, because again, all of that is discoverable and ultimately it could be used against you in the court of law. This is Frank Hartman with the Hartman Law Firm, and today we talked about the role of social media in the context of your auto accident trial and what you should be aware of, the potential potholes. If you're watching this video, chances are you've got questions. I would strongly encourage you to pick up the telephone and call me, Frank Hartman, at the Hartman Law Firm at 843-300-7600, or look me up at thehartmanlawfirm.com. And again, thanks for watching.